Hi, good afternoon if you are on the East Coast, and good morning if you're out west. My name is Lacey, and you're listening to a year in roundup of the U.S. Department of Education's rulemaking activity, which is part of the Thompson-Coburn Higher Education webinar series for 2019-2020. I'm going to go ahead and start us off here with some housekeeping while folks are still dialing in. As always, this presentation, like all the presentations in our series, is CLE accredited. That's continuing legal education. So if you're an attorney and you're looking to pick up CLE, you're in luck. It's accredited for 1.8 hours of general credit in Missouri, hour and a half of general credit in California and Illinois. If you're in a different state, we can work with you, or you may need to do a little extra work just to get it qualified in your jurisdiction. We award CLE based on attendance for the entire 90 minutes. This is a 90-minute presentation today. From time to time, you'll see a pop-up screen, and you'll need to click that just to reflect your continued engagement. We've got some widgets I want to run you through. If you have any questions during the webcast, first of all, you can submit them through the Q&A widget, which is at the bottom of the screen. I'll try to answer as many of those questions as I can. If there are questions that I'm not sure on, we can always circle up offline, but we like to try to get everything answered that we feel like we can get to. A copy of the slide deck for today is in the resource widget. Also, there are a couple of other excellent resources in there today. We included a couple of reporting guides that I'll reference during the presentation. And then if you have technical issues, in the help widget, there are some answers to some common technical questions. Finally, we do have a post-webinar survey, and we really do value your opinion, and always appreciate if folks can take a little time just to tell us what they thought and give us any feedback. We do try to make every presentation better than the one before. Thompson-Coburn, for those of you who may not know us, we're a big law firm, so we have a little over 380 attorneys with offices all over the place. I'm sitting in St. Louis looking out over the Arch right now, as a matter of fact, but we also have folks in Chicago and LA and DC, among others. And we think we do a pretty good job with providing exceptional value to our clients, and we were actually recognized for that recently. I've added this in. I've noted that sometimes folks don't know that we are a law firm, so I thought I should probably mention that at the outset. I am the leader of our higher education practice, so within our firm, we have attorneys who work a great deal with colleges and universities. I also host this webinar series. Here are some of the lovely people that I work with, along with some of the areas that they practice in, and it is really a great group of folks, and I certainly consider myself fortunate to have the opportunity to work with them and to work with you all in the higher ed community. The webinar series, I mentioned this is part of our series. We do webinars. We sort of track the academic year, so we start in the fall and run through the spring. This is concluding our fall series, so we do one more or less each month. We'll start up again in January on the other side of the break, and you see there in the spring we'll be doing some presentations on HR-type issues. We'll be talking about some noteworthy administrative decisions from the U.S. Department of Ed, and then we'll get into immigration, intellectual property, and then in May, cannabis and higher education, which I know is always a hot and interesting topic. By the way, these links in the presentation are active anytime you see something in gold that's underlined or yellow, depending on the color of your screen there. You can click that, and it should take you to, in this case, the recordings of those webinars, and they are all free and on demand and just sit on our website. So usually this is where we introduce a little bit about the speaker. It so happens I'm the host of the series, but I'm also the speaker today, the one taking you through the regulatory stuff that's been going on at the department. And that's really the core of my practice. So all of my clients are colleges and universities. I do a lot of regulatory counseling and really specialize in the federal, state, and accrediting agency laws and standards that impact higher education, and along with the several other attorneys in the firm, do a lot of work on transactions and M&A in the post-secondary space in all sectors where it is happening right now, whether that be private, nonprofit, for-profit, and even in the public sector as well. And then all kinds of contract drafting and policies and all of those things that you all know that institutions of higher education do every day. I'll just note here at the bottom, in 2018, I was appointed by the U.S. Department of Education actually to serve as a negotiator on the rewrite of the Bar Defense Rule. And I only highlight that because that's one of the regulations we're going to talk about a little bit today. So There is a lot to talk about, and that's because the U.S. Department of Education has had a really ambitious regulatory agenda that it's been working through over the last couple of years. And here you see the 5 items I'm going to try to hit on today: the Accreditation and Innovation Rulemaking, state authorization, bar defense to repayment, Title IX, and gainful employment, and all complicated rules, and I would say all pretty controversial in one way or another. I think there's been litigation surrounding almost every one of these, at least in some respect, which just makes it interesting, but also challenging for institutions of higher education where you've got Congress or the courts I won't say interfering with, but impacting the regulatory process and the implementation of some of these regulations. And those of you who are on campus and have been tracking these rules and thinking about how and when to implement various versions of these rules know exactly what I'm talking about. It's a difficult thing to do and can be time-consuming and costly. Hopefully, we can give you a little bit of a sense as to where things are today and maybe ease that burden just a shade. So I'm going to walk through each one of these. We have a lot of ground to cover. And again, I want to make sure one of the reasons we did 90 minutes is because we wanted to try to include some time for questions. So I'm going to start with the Accreditation and Innovation Rulemaking. And let's talk about the scope of the rulemaking. Every one of these rules is extraordinarily complex. I mean, when these are coming out and proposed for final version in the Federal Register, those of you who have visited those documents know they are hundreds of pages. So I'm not attempting in 90 minutes to give you a thorough soup to nuts review of each one of these regulatory packages. My goal is to sort of give you an overview of where things are, but also we're going to drill down on certain aspects of these various packages just to try to highlight for you a few things that you might want to be thinking about, and also try to hook you up with some additional resources. So accreditation and innovation, the rulemaking that was announced late 2018 and really carried out earlier this year quite successfully actually by the department, covered a lot of ground. And in fact, when it was announced, it covered so much ground, some people questioned whether the department could really get it done. Recognition of accrediting agencies, so we're talking about the rules and procedures that govern the recognition of the accreditors themselves and what accreditors that are recognized have to do to stay recognized. So these are not rules that apply directly to schools, but they certainly impact schools insofar as they say, if you want to be a recognized accreditor, you've got to do X, Y, and Z. And of course, if that accreditor is doing X, Y, and Z, it's going to impact the schools that it accredits. State authorization of distance education programs, which was sort of pulled into the Accreditation and Innovation rulemaking. Previously, it had been treated sort of as its own independent rulemaking, and for the purposes of this presentation, I'm actually going to carve it out and talk about it separately, though here at the end, again, it was sort of combined into the Accreditation and Innovation rulemaking process. The Byrd Honor Scholarship Program, eligibility of faith-based entities to participate in the Title IV programs, new rules for teach grants, and rules for distance and competency-based education. So talking about, sort of the rules that the department's going to employ when it's evaluating those types of programs. By the way, I'm just going to take a quick second here and note, I am recovering from a cold. You may have noticed that, those of you who tune in regularly. I'm a little hoarse today, so if you hear me pause occasionally, it may be just to get a drink of water. The rulemaking timeline. So for each one of these rules, I've tried to lay out for you sort of the historic timeline and include some links so you can get to key documents if you want to go back and look at those. For Accreditation Innovation, it's actually not that lengthy a timeline. The department only announced last summer that they wanted to do this, and you'll see later some of these rulemakings have been going on for years and years, so 18 months is pretty good for the department. It carried out, put out some documentation and was soliciting information from the regulated community in the fall of 18, and then actually carried out the negotiated rulemaking in January, I'll just say the spring of 2019, so first part of this year. And as you'll see here at the end, towards the end of that blurb, on April 3rd, 2019, the committee reached consensus, which was a big deal, right? It's been a long time when these negotiated rulemakings happen and you get all these people sitting around the table. The only way they reach consensus is if everyone agrees to every word that's been proposed by the committee on all the topics. And of course, this rulemaking covered this extraordinary range of topics. So the fact that the committee managed to get to consensus and everyone was in total agreement was, I think it's fair to say, unexpected and certainly a win for this administration. It's good for the regulated community because I think it creates a lot more, a much greater sense that these rules are going to have lasting effect and should be honored from one administration to the next. So the department published its proposed rule June 12th. And they managed to get the final rule out November 1st, 2019. But it's important to note that this proposed and final rule that we saw in the summer and then fall of this year didn't cover all of the different areas that were considered during the Accreditation and Innovation negotiated rulemaking. They only covered those relating to accreditation and state authorization. What the department has decided to do is, rather than try to create one massive rule that covered all these areas at once, it's sort of broken it up into different sub-packages, right? So we saw the proposed and final rule around accreditation and state authorization in the summer and fall of this year. And then only last week, December 11th, 2019, the department put out its proposed rule in the Federal Register relating to faith-based institutions and revised rules for teach grants. If you are listening right now and you are an administrator at a faith-based institution, please note that you can click on that little link where it says proposed rule and it'll take you to the Federal Register. You have, the comment period is open right now, and you have through January 10th to file those comments. And if you need help understanding how to do that, feel free to give us a holler. So I mentioned a second ago, the department sort of divided the accreditation and innovation rulemaking into different groups. This was an effort on my part to sort of give you a sense of how that is looking right now. So we've got three tranches in a sense. The first tranche involved recognition of accrediting agencies, state authorization, and the Bird Honor Scholarship Program. We're going to talk about that more today. And we've got the final rule. So that's the one that came out November 1st. The final rule has been published around those topics. The proposed rule that we just saw that came out December 11th, and I just mentioned the comment period is open right now, again covers faith-based entities and their eligibility and new rules for teach grants. And then the final piece that we've not yet seen that is still being managed at the department are the rules for distance and competency-based education. And these are all sort of proceeding then on separate tracks. Looking ahead, so what we would anticipate, keep in mind this is speculation on our part, but what we would anticipate is in winter of this year, and by that I mean January, February, March, we may see a proposed rule covering distance and competency-based education. In the spring, we think it's possible the department could actually get its final rule out around faith-based entities' participation in Title IV and the teach grants. That would be, again, the comment period for the proposed rule closes in January. Assuming you have a modest amount of comments around those areas, we would think a couple of months and the department conceivably could get to a final rule, particularly because, remember, the proposed language was based on the consensus of the negotiated rulemaking committee, so it's not as controversial as other rulemaking packages have been. Summer 2020, we may then see a final rule covering distance and competency-based ed, depending on how much feedback the department gets. Okay, and so here are your two big effective dates, right? So July 1, 2020, that's the effective date of the final rule we already have that came out this November 1st relating to accreditation and state authorization. So that is signed, sealed, and delivered, issued in final form November 1st, which means under the department's master calendar and the statutory framework, that rule becomes effective the following July 1, which will be July 1 of next year. All of the other stuff that is still percolating, if it all gets finalized by November 1 of 2020, that means it could become effective by July 1 of 2021, right? So that sort of gives you a perspective timetable on the accreditation and innovation rulemaking and the various pieces that are being worked through right now. So I want to focus on a couple of things that were part of the November 1 reg, right? So the first is I want to talk about some of the changes to accreditation rules. Again, this is not a comprehensive review. If you would like us to do a webinar where we do a soup to nuts review of the accreditation and innovation rulemaking, let me know. Let me know in the survey comments. I mean, we try to cover a lot of stuff. If you see a new Title IX rule, I suspect we will do a soup to nuts on that one, but have not necessarily put that on the calendar yet. So if you'd really like to see it again, maybe fill out the survey and let me know. But I do want to talk to you a little bit about what has changed, because again, while these rules impact directly your accreditors, they indirectly impact you, right? So there are a number of important changes that have been made with this new final rule that came out November 1st. Under the new rule, and again becomes effective next July 1, the new rule permits accreditors to use alternate standards when special circumstances exist. So if you've got innovative educational models, for example, they can actually come up with alternative standards for approving those alternative education models, and previously they couldn't do that. They had to use the same set of standards for everything, and that was a problem, right? Because certain types of educational innovations and delivery models really didn't lend themselves to being approved by that same tried and true and long used set of criteria. It formalizes the permissibility of retroactive accreditation. Most of you know a lot of accreditors will not get around to issuing grants of accreditation until after the prior grant has expired, and then they'll retroactively apply the date of that new grant. This just makes it clear that that's permissible. Significant changes to the requirements surrounding substantive changes. So the department has, in this new rule, added a little more meat around what should and should not be a substantive change, and also created some more flexibility for accreditors in how they approve those substantive changes, particularly in some cases noting that staff can approve certain substantive changes. That's important and will be meaningful for schools, I think, as it flows through into the accreditation standards and criteria themselves. Creates new flexibility for the management of noncompliance, meaning the new rule gives accreditors additional flexibility in how they go about managing noncompliance on the part of institutions that they accredit, and that's what I'm going to talk about here in a few minutes. And then finally, the department and the new rule has attempted to offer some additional clarity around distinguishing a teach-out plan from a teach-out agreement, and what accreditors need to require in the way of teach-out planning. This, of course, has been in part and was a topic of hot conversation in part because we've seen a lot of contraction and consolidation in higher ed, and there are a lot of locations, a smaller number of schools, but some schools that are in the process of teaching out, right? So these are all important things to be mindful of that are in this new rule, and what you as institutions, and I think the regulated community, really want to look for is what your accreditors are doing to respond to these new rules, right? So the rules become effective July 1 of next year, but I anticipate that the accreditors will begin looking at the new rules and thinking about how they want to adjust their standards and their policies to reflect these new rules, and in particular the increased flexibility that they provide. And then they're presumably, most of the accreditors, the way it works is they will propose to the accredited community these changes. So you as institutions will want to be on the lookout for proposed revisions to your accreditors' criteria or standards that will reflect some of these changes in federal law. And a lot of them, again, they're important. So you'll want to review those carefully, or whoever at your institution is responsible for that kind of thing. I want to take a minute. I want to focus on the increased flexibility for the management of noncompliance, that bucket, okay? So importantly, I think, the department has recognized the value of affording accreditors increased flexibility in how they work with and manage noncompliance on the part of their institutions. There were situations in recent years where I think there were accreditors who felt if they had increased flexibility, they could have successfully worked with an institution to get them back into compliance. But because of some of the timeframes that were required under federal law, they weren't able to do so. And sometimes that was to the great detriment of the schools and their faculty, staff, and students. So one of the things the new rule does is allows for focused adverse actions. Under current law, accreditors don't have a lot of flexibility when it comes to taking an adverse action against an institution. If you're an institutional creditor, you're limited in your ability to focus that adverse action on a particular program or a particular location where the issue may actually exist. Rather, the action often has to take place against the entire institution, which can be alarming and is unnecessary. And so one of the things the new rule does is it clarifies that accreditors can limit an adverse action, quote, to particular programs that are offered by the school or to particular locations of the institution, provided that the non-compliance at issue is limited to those programs or those locations. But that's great because it means that accreditors on a go-forward basis will be able, in a more surgical way, to let schools know that there's an issue without implicating necessarily the entire institution, when in fact the entire institution doesn't need to be implicated. So that's good. This is really important. The new rule will allow for noncompliance beyond the school's control. It creates more flexibility when you have noncompliance that's being created by external factors. So specifically under the new rule, accreditors now can permit noncompliance for up to 3 years or more for good cause if the circumstances causing the noncompliance are beyond the institution's control, critical concept. The accreditor's decision-making body, that means the commission or the board, has approved the period of noncompliance. The accreditor believes that the institution can achieve compliance within that time that's been allotted. And the institution demonstrates that the period of noncompliance won't harm students or compromise program quality, right? So what do we mean by circumstances beyond an institution's control? The department in the new rule actually gives examples. So they say natural disaster, catastrophic event, accepting students from another school that's in teach out. So, you know, if you have an influx, if you're trying to do a favor, there's another school that's closing or struggling, and you say, okay, we'll take in a bunch of their students. But by virtue of taking in that cohort, it impacts you in some way. You can't get as many placed, or their test scores aren't as good, or, you know, in some way it impacts your ability to comply with your accreditor standards. There's an allowance for that. There's an understanding that, you know, you're trying to do good work. You're taking on students. That's why your performance or metrics or whatever may be a little out of whack. Significant and documented national or local economic changes, right? So if there's a recession, a national recession, and that impacts your ability to comply with certain accreditation standards. Changes to state licensure requirements. The normal application standards creates an undue hardship on students. And sometimes that happens in a case where an institution is sort of uniquely or particularly situated. Or maybe you have instructors in a dual enrollment or technical program that don't meet your typical faculty standards. So you roll out a program and, you know, you need someone who's got significant experience in a technical field, but maybe they don't have any, you know, training in how to teach or educational pedagogy or something along those lines, and as a consequence would not satisfy the typical faculty standard. There's sort of an understanding and allowance for that. So I think this is really good. It creates a lot of additional flexibility for accreditors to have a conversation with the school, and for a school to say, look, you know, we're not satisfying this standard right now, but it's because of this circumstance beyond our control. You know, we're going to be able to come into compliance, though, and manage that circumstance over a 2 or 3 or 4 year period, and have that conversation and allow the school to work through that time frame and get back into compliance. The new rule also would extend the time frame for resolving identified noncompliance that may not be the result of circumstances beyond an institution's control. So if an accreditor actually identifies noncompliance, you know, you have a team visit report or something like that, it can now provide a school with a compliance timeline up to the lesser of 4 years or 150% the length of the program, if it's a programmatic issue, or the length of the longest program at the institution. So, you know, if you got a bachelor's degree program, you could be talking about 6 years. Or 4 years, rather. I'm sorry. It's the lesser of. So it'd be 4 years. But if you had an associate degrees program, I guess, that was a 2 year program, rather, then it would be a 3 year. But the point here is, under current law, it's 2. So, you know, you're talking about significantly increasing the period of time. And again, good cause extensions are permitted. And you know, in our practice, I've seen, I'm sure many of you, if not at your institution, have colleagues in the industry at other institutions where who can give examples. But, you know, I've seen examples where something changed, like a state law, for example. I know there are schools that have nursing programs, and sometimes states will change the timelines for when students who complete a program can actually sit for exams, right? And that may impact how soon those individuals, those graduates, can get into the workforce, and that can impact how many are actually captured in placement statistics that some accreditors require, or some programmatic accreditors may require, right? Because the window for placement closes before those individuals can sit for their exam based on the new state law and the cycle that the state uses for letting folks sit. The point is, you've got a state law that has changed. Nothing has changed with regard to the quality of the institution or its programming or the fitness of its graduates, but just by virtue of this state law change and the way their process has played out, it's going to impact the ability of the institution to comply with the accreditor. In this case, maybe the accreditor has some sort of outcome metric, right? And so this, I think, allows more flexibility, these rules, for accreditors to say, okay, we understand, let's work with you and figure out how to get you back into compliance with our outcome metric, and now you've got several years to do it. And we all know when you're making adjustments, to programs, and it takes time for those to flow through and for the outcomes to actually be impacted. So this is all really positive, I think. Now, keep in mind, these are caps. These are not requirements. So an accreditor could elect not to give institutions up to 4 years. They could just say, our commission has voted, and under our standards, you get up to 3 years, even though federal law would allow up to 4. And that's a really important point, and that's another reason I say, these are the laws that apply to accreditors, and so the law that applies to accreditors has become more flexible. But your creditor could ostensibly elect for a more restrictive time frame for compliance. And that's why you want to pay attention to what your creditors are doing in reaction to these laws and how they're syncing up their criteria and standards to this new flexibility. Now, if you were paying attention, the last two, we had two slides there. One was talking about noncompliance due to circumstances beyond a school's control, the other, any kind of identified noncompliance. And, in one case we had a 3-year plus more for good cause, and the other we had 4 years. There were folks who came back to the department after the proposed rule came out and said, well, why aren't you just syncing up these timelines? It seems a little confusing, that you've got 3 years in one and 4 years in the other, and there could be some tension or conflict. And, the department said, look, we disagree that we need to be consistent between these two concepts. The regulations intentionally provide latitude to the accrediting agencies to establish timelines that are reasonable and appropriate to their processes and procedures. And this, again, just reinforces the idea that the department is creating caps, ceilings, however you want to think about it, but they're sort of saying this is the maximum, but the accreditors have flexibility to work within that maximum, and you want to pay attention to what your accreditor decides to do. And so your accreditor could sync it all up and say in any case, whether it's due to outside circumstances or an identified noncompliance, it's always going to be 3 years. And we're not going to allow for a further extension due to good cause. So again, keep that in mind. Refines the scope of oversight. A couple things on this slide that are important. So one of the things that the department was trying to do through this rulemaking is to better clarify the roles of the members of the triad, meaning the U.S. Department of Education, the accreditors, and the state approving, or not state approving agencies, but rather state authorizing entities, the agencies that authorize schools to provide post-secondary education. So they explicitly stated in the new rule that accreditors are not responsible for enforcing various federal obligations under the Program Participation Agreement, Financial Responsibility, Administrative Capability, Consumer Information and Clarity Act. So that's a lot. But, and I also wanted to highlight this, under the new law, there is now an affirmative obligation on accreditors to notify the department if in the course of their work they identify instances or potential instances of noncompliance. So one of the concerns, I think, among schools, in addition to the regulated community, has been sometimes there's a lack of coordination and communication among the parties of the triad. And even the different parts of the triad, I think, have expressed some frustration over this. On the other hand, we may not always be crazy about our accreditor forwarding things that they found to the U.S. Department of Education. And in the past, it's been inconsistent. Some accreditors will copy the department on certain significant actions, but not on others. Now, there's this blanket affirmative obligation on accreditors, not only to give a heads up to the department with regard to noncompliance, but also potential noncompliance. It's going to be very interesting to see what that really means in practice, right? It's hard for me to imagine that the accreditors are going to start copying the department on every team report that has recommendations or cites potential noncompliance. Some accreditors might. Some may choose not to. It's also, I think there's an open question as to, really what capacity the U.S. Department of Ed has to, evaluate all this information if all the accreditors start providing them with every report of noncompliance or finding. But this is something that the regulated community is going to want to pay attention to. And keep in mind, again, I know sometimes there's a sense that some of these rules are targeting one industry or sector of higher education over another, but, this is not specific to any particular sector of higher ed. So if you're a public university on the line, I know we've got private nonprofits, for-profits, everybody listening in today. I mean, all of your accreditors have this obligation, right, because they're recognized accreditors. So, you're going to just want to be mindful of the fact that on a go-forward basis, when you have team visits or site reports, things like that, we're going to be in this process of figuring out exactly what our accreditors are going to start providing to the department, who at the department's going to get it, and what the department's going to do with it. A lot of new information flowing to the department under these rules. A lot of new information, right? More, frankly, than I think their current infrastructure has the ability to to review or deal with. But, over time that could change. It's just that has yet to be seen. Just be aware that you've now got this obligation and that presumably there will be some increase in what is flowing from the accreditors to the department. Okay, keep in mind that was not a comprehensive review of all of the changes that occurred in Accreditation Innovation rulemaking or even in the accreditation section. That's just the focal point that I wanted to hit on, make you aware of some of those things. Similarly, now I want to talk a little bit about state authorization, which again was wrapped into, at the end here, accreditation and innovation, but it hasn't always been that way. For many years, state authorization was sort of on its own path, and within those discussions around state authorization, there were sort of three big buckets of information that were being discussed. One was the authorization of distance education. So, how do we manage the authorization of programs that are being offered by an entity or an institution to individuals in different jurisdictions in different states? The authorization of foreign locations, and disclosures for distance education programs with a specific emphasis, I think, in recent years on those that lead to some form of professional licensure. Here's the timeline. Like I said, it goes all the way back to 2010, and what we ultimately have ended up with here is the third iteration of the state authorization rule. I'm not going to go through all this in detail, but back in 2010, the department offered up its first version, and they were sued, and it was actually taken down by a court decision out of the U.S. District Court of Appeals for D.C., which affirmed the district court decision. So in 2016, the department proposed another state authorization rule, but it didn't end up in final form until 2018, which meant that it could not become effective until the earliest would be July 1, 2019, and then the department actually decided in 2018 to delay the rule further until July 1, 2020, and this is where the real confusion started. At about the same time, the current administration said, okay, so not only are we going to delay that 2016 rule until 2020, but in the meantime, we're going to develop a brand new 2019 version of state authorization rule. And we're going to do that in the context of the Accreditation and Innovation rulemaking, and they did, right? Reached consensus. And that final rule, the 2019 state authorization rule, was promulgated on November 1st of 2019. But in the meantime, back in August of 2018, some folks sued the department and said, well, we think your delay of the 2016 rule violated the Administrative Procedures Act. And in April of 2019, the U.S. District Court for the Northern California agreed, and they actually vacated the delay of the 2016 rule effective May 26, 2019. And I was speaking earlier this year at a state authorization workshop that was held by the SAN network, and we joked at this point, and then on May 27th, everybody went out and make sure they were in perfect compliance with the 2016 rule. Probably not true. That got a decent round of laughs, and unfortunately, it just doesn't work that way. What really happened was there was a lot of concern in 2018 spring about coming in compliance with the rule, and then this administration delayed that rule, and then it kind of fell off the radar of a lot of folks. And when this court decision came down in April, and then ultimately in May, the 2016 rule suddenly became the law of the land. There was not a lot of acknowledgement of that fact. And I think it's been a slow road since then for the department and for institutions to appreciate that this 2016 state authorization rule is on the books and actually has some affirmative obligations that come along with it. So where does that leave us now? I want to focus on a couple of things. The first is I do want to talk about some limits on reciprocity that the 2019 rule that just went into effect, how that sort of plays out. And then I want to circle back to these disclosures under the 2016 rule and then how they're changing in 2019. But first, just real quick, let's talk about reciprocity. So, one of the big, I think, aside from California, all the states now are part of SARA, right? NC SARA, which is the sort of prevailing state authorization reciprocity agreement out there. And many institutions are members of SARA, particularly if they offer online education. And what that means is, ostensibly what it means is, if you're authorized by your home state, then all of those other states that participate in reciprocity, California being the lone holdout, all of the others, agree that you can offer education into their state. But there's been some confusion, and I have conversations regularly with clients about this, and folks will call up and they'll say, okay, we're in SARA, we're a SARA participating institution, so we understand since we're authorized in our home state to offer higher education, we don't have to be authorized in these other states. But what does that mean? We have to comply with their, Secretary of State's registration requirements. If our presence is sufficient enough that it doesn't constitute a physical presence outside of what SARA would permit, but for some reason the state now is telling us we have to be registered to do business in their state, not authorized as an educational entity, just registered with the Secretary of State. Or what about, criminal laws or all these other things that are outside of the state authorization? And there can be some real confusion around which laws don't apply in those other states and which laws do apply. And I think the department, we know the department and the community were trying to address sort of the limits of reciprocity in the context of this rulemaking. And they've said a couple of things. So schools participating in state authorization agreements, similarly are considered authorized, subject to any limitations in the reciprocity agreement, as well as to any additional state requirements outside of the reciprocity framework. So if you're participating in SARA, the department generally left the reciprocity framework in place that existed under the 2016 rule. So the new 2019 rule generally left that in place, right? You're still authorized, right? You can still rely on that reciprocity. But what you need to understand, and I know the general counsels on the line will get this right away, and some of the non-lawyers certainly will as well, but there may be others out there in your community who deal with education and your online education who may not understand this. So this is an important point to make for them, right? This reciprocity only extends, right, to the state authorization concept. It is subject to any limitations in the reciprocity agreement itself, and there are many limitations, right, in the NC-SARA reciprocity agreement, right? And the school is still subject to any additional state requirements that are outside of that reciprocity concept, which again only covers state authorization. So, not only would that include like being registered with your Secretary of State, but it could also include your nursing board in that other state or professional licensure bodies in that other state, because they aren't part of the fundamental authorization to offer post-secondary education. They're about licensing professionals, right, or particular programs and requirements for particular programs. So there's still a lot to potentially contend with depending on the kind of education that you offer. And the department wanted to make this point really clear. They said, look, the new rule clarifies that, and this is quoted out of the regulatory language, an agreement cannot prohibit any member state of the agreement from enforcing its own general purpose state laws and regulations out of the state authorization of distance education. So the department makes really clear now in the text of the regulation itself that even if you're part of a SARA, a state authorization reciprocity agreement, NC-SARA or otherwise, right, that does not mean that the state in that other jurisdiction can't still enforce all its other laws vis-a-vis your institution. And that's just a really important concept to understand. And this secondary language here was out of the Federal Register. Just to hit it home, the department said, look, the scope of the state authorization reciprocity agreement can't be interpreted to extend beyond the scope of state authorization of distance education or to impact that state's exercise of its other general oversight activities. And by the way, one of the reasons the department went out of its way to clarify this is because states were concerned. Right? I mean, you had attorney generals in states saying, well, I've got schools that are suggesting to me that because they're in SARA, I can't deal with them or exercise our other consumer protection statutes, right? Or our nursing board or just or tax or, corporate, any of that. And again, that's not true. The reciprocity only covers authorization of distance education. All the other laws of that state still apply to you, and you need to be very aware of that. And the department's made that clear. On the other hand, the department also observes, and I appreciated that they included this, that it would, quote, not be acceptable, this isn't in the law, but this is in the Federal Register in the commentary, not be acceptable for a state to participate in a reciprocity agreement in order to advantage its own public institutions and yet apply additional or alternate requirements related to state authorization of distance education to institutions that participate in the reciprocity agreement but may be located in different states. Okay, so if I'm in my home state and I'm participating in SARA and I'm beaming my education into a foreign jurisdiction, right? And I participate in SARA, the foreign jurisdiction participates in SARA. Insofar as we are talking about the rules and regulations concerning state authorization of distance education, what the department is saying here is, that foreign jurisdiction has to apply the same rules around that authorization of distance education that they apply to their own folks, right? Because they participate in a reciprocity agreement. They can't come up with new rules or different standards for schools that are coming into their state, right? But again, so it goes both, it's sort of two sides to this coin, right? So on the one hand, when it comes to state authorization, they have to treat you the same way if you're beaming into their jurisdiction. On the other hand, keep in mind, they can apply all their other laws that are unrelated to state authorization of distance education to your school, right? And SARA doesn't have anything to do with that, and it's really important to understand sort of where the lines are drawn. Okay. The other focal point I wanted to talk about, and this is probably the thing I'm hitting the hardest in this presentation today, because I think it's important, and I think it's a trend that's been here and is not going away, and it's something that schools, I think, probably would be good to take a step back, not only in the context of this conversation, but just generally and reevaluate. Something else we've talked about doing next year in our practice is potentially offering up some sort of extended consumer information boot camp or something along those lines to really work with schools through all these various consumer information requirements. If you like that idea, again, let me know. Shoot me an email or provide some feedback in the survey. But for now, let's talk about the changes to consumer information that are being brought about by this new Accreditation and Innovation Rule, particularly in the area of state authorization. Okay, so under the 2016 rule that became effective this past May 2019, when that California court, right, issued the department's delay or found the department's delay to be illegal, essentially having violated the APA, right? So May of 2019, the 2016 state authorization rule became the law of the land. And it is in effect and will remain in place until July 1, 2020. When the 2019 rule that we just saw in final form on November 1st of this year, when it takes effect. So between now and July 1 of next year, the 2016 state authorization rule will remain the law of the land. And it includes significant disclosure requirements that are in place right now. We call them make available and direct disclosure requirements. The make available, these are the ones you have to put on your website and in your materials, and the direct disclosure requirements are the ones you actually have to hand directly to students. So you sort of have two buckets from the department, right? Those disclosure requirements are in place right now and will remain the law until July 1 of next year, okay? They are robust and complicated. I'm not going to go through them in great detail. We've done that already. There's a free and on-demand webinar we did that you can click that link that reviews the 2016 state authorization rule. We also did a compliance chart that goes through the reporting requirements in detail. So if you don't know what those requirements are and you need a refresher, here's a place where you can go get all of those, right, for free. There's an early implementation option for the 2019 rule. So again, the 2016 rule will remain the law of the land until July 1 of next year. But when the department put out its new 2019 rule on November 1st of this year, they said, hey, we have the ability under the statutes that govern our agency to allow schools to early implement regulations when we put them out. And we're going to allow schools, if they want to early implement the disclosure, consumer information requirements in the 2019 rule. So in other words, you can ditch the requirements under the 2016 rule and then decide to adopt the requirements under the 2019 rule before July 1 of next year. All right, so let's just be clear. If you do nothing, you have to comply with the 2016 rule until July 1 of next year. But you have the option to early implement these new requirements that have come out in the 2019 rule. So the question is, what should you do? And what I want to emphasize to you all on the phone is this is not a matter of just ditching the old requirements and not have anything new to do. And I'm going to go through this. There are significant requirements that come along with the 2019 rule. So you should be complying with the 2016 rule right now. And if you decide to early implement, the day you early implement, you need to be prepared to shift over and start complying with the 2019 rule. And this is different from gainful employment, for example, which I'm going to talk about at the very end, where this administration just said we're just rescinding the old rule. So if you early implement, you basically just get to quit complying with the old rule. That's not the case here. Here, you can quit complying with the old disclosure requirements, but on the day you do that, you have to be prepared to be complying with the new requirements. So it's a deliberate and informed decision that you need to make. And when you early implement, you got to be prepared to make the shift, right? So let's talk about what will be involved in making the shift, right? If you're complying with 2016 right now, which hopefully you are, or if you're not sure you are, you can go look at that prior slide and go back and look at our webinar and our reporting guide. If you're thinking about early implementing, I'm going to walk you through right now what the changes look like, okay? So what they've done, this administration has said, you know, the state authorization rule is always focused on distance education. And all of those disclosures that were being made, including the ones around professional licensure, programs that lead to professional licensure, they were all applicable only to programs that were distance education programs. But this administration has said, you know, that doesn't make sense to us. We think that students and all programs need this information. If you're in a professional licensure program, it doesn't matter if it's online or on the ground. There's certain stuff we think you ought to know. So what we're going to do is we're going to eliminate most of the 2016 requirements, disclosure requirements, or a number of them that were specific to distance education we didn't like. But we're going to take some of the stuff that we do like, and we're going to move it over into the consumer information section of the regulations that already exists, where you find all kinds of stuff, right? And now it's going to be part of that consumer information block of content that schools have to provide, and it's going to apply for all programs and all students. It's not specific to distance education anymore, right? So this is what the department said. Pursuant to 668.41d, and this is, let's take a step back, actually. I misspoke. So before I get into what the department said, let me just refresh you as to where that consumer information stuff is currently located, right? So pursuant to 668.41d, institutions already are required to make available to any enrolled student or prospective student through appropriate publications, mailings, or electronic media information concerning a wide range of topics, including a whole host of stuff about financial aid that's in 668.42 and a whole host of stuff about the institution that's in 668.43. And this includes information about financial aid and housing and costs and the CLARI Act, and all of that stuff is built into the current consumer information requirements. So the new rule does away with the sort of concept that we're just dealing with distance education and says, you know, instead we're just going to revise and expand the consumer information stuff, right? That's already in 668.43. Okay, so take a deep breath. This is just some of the stuff that's currently required that you put out every year as part of your consumer information under federal law. This has nothing to do with what's changing. This is already on the books. All of these blocks are already on the books, right? Cost of attending, refund policies, withdrawal procedures. Now the good news, I'm not going to go through all of them. The good news is most of this stuff you've got in your catalogs and on your website, and you've been doing it for years. Every year you're supposed to put out a notice to students telling them where they can get all of this stuff, right? You have your CLARI Act stuff that you put out. You've got your FERPA stuff that you put out. So most of you hopefully have sort of a consumer information process. You've got places in your materials and on your website where a lot of this stuff is housed already, right? But if you haven't thought about this in a while, I want to encourage you now to refresh, because the law is changing, right? Whether you early implement or you wait until July 1 of next year, it's changing. And frankly, my experience is most schools don't have all of this down pat and aren't doing it all perfectly. And that's not a shot. Look, I was in-house for years. It's hard to do. I mean, in addition to the federal law, you've got your creditors and the states, and the amount of consumer information we're expected to provide to the public and to our students and our faculty and staff now is overwhelming. But here's my message. It's not going away. Right? That's the way regulators are thinking about things these days. That's their solution to a lot of concerns. There is no scenario in my mind where all of these consumer information requirements cease to exist. I think it's just going to continue to increase, frankly. Now, you may have revisions to what's being provided, how they want you to provide it, but if you have not already done so, it is absolutely worth just investing in this idea that institutions of higher education are going to have to be very, very good at consumer information. It's like the banking industry or healthcare. There are just lots of disclosures that you're going to have to make, right? So it's a good time to sit down and reevaluate how you're doing that, how you're collecting information, where you're presenting it, and also to think about, are we doing what's required under the 2016 law, and what is changing in 2019 that we need to be ready for, and how soon are we going to be ready to implement it, right? The boxes with gold around them, those are the things that the 2019 rule changes. right? So it either revises the way this information is already being provided, or it adds additional information that they want you to provide, right? But these are the places where there's some change, right? So information relating to academic programs, transfer credit policies, written arrangements with other institutions. See, it's not just the distance education stuff, right? It's touching on a lot of different pieces of the consumer information puzzle, in addition to, at the very bottom here, right-hand corner, all these direct disclosures for licensure determinations. Okay, so just keep in mind what this administration is doing is they're essentially using this rulemaking to refresh and overhaul the consumer information requirements. And so they've taken some of the stuff that previously was being done in the distance education context, and they've moved it over into the part of the law that long has existed and relates just more generally to consumer information. Okay, so about some of the specific things that you're going to have to do under the 2019. So the bulk of the DE program distance education disclosures under the 2016 state authorization rule that you are supposed to be making right now if you offer distance education, those will be jettisoned entirely. However, disclosures relating to professional licensure, which are some of the more complicated and probably time-intensive ones to put together, they won't only remain, but they're going to be applied to all programs without regard to whether they're offered online or on the ground. And this is what the department had to say about this. The department notes by moving disclosures from 66850, that was the distance education reg, which only applied to distance ed programs and correspondence courses, to 66843, which applies to all Title IV eligible programs at institutions of higher ed, the department broadened the scope of these requirements so that more students can make informed enrollment decisions. Under the new rule, a covered licensure program is one designed to meet educational requirements for a specific professional license or certification that is required for employment in an occupation or is advertised as meeting such requirements. So is it required or are you advertising it? And I get this question, and it's an important one for schools to think through. I mean, sometimes there will be optional certifications that graduates from certain programs can obtain. If it's optional, then it's not required. But if you're advertising that folks who finish your program will be eligible to sit for that certification, then you've pulled yourself right back in. Okay, so you got to think about, is it required, and or are we advertising that we are preparing folks to get this certification? For each program that you determine is a covered licensure program, again, whether it's online or on ground. So, if you're in Memphis, Tennessee, and you have nothing to do with online, but you offer an on-ground nursing program, right? That's a licensure program, almost certainly, right? And you may have students from Mississippi, from Arkansas, from Missouri, and from Illinois, because all those states are awfully close to Memphis, right? And so now you're going to have to start thinking about whether or not you need to be providing information to these students with regard to your program and the extent to which, if they graduate, they'll be able to go back to their home states, right? So for each covered licensure program, you have to make available, so we're going to start with make available requirements. This isn't stuff you have to hand to them directly. This is stuff you just have to put on your website or in your materials. You have to make available, quote, information regarding whether completion of that program would be sufficient to meet licensure requirements in a state for that occupation, including, okay, and so this is the department includes in the reg. When they talk about information, which I've highlighted here, this is at a minimum the information that they're talking about. So if you've got a covered licensure program, whether it's on ground or online, when you implement the 2019 rule, or no later than July 1 of next year, this is what you're going to have to make available. A list of positive licensure determinations. So a list of all states for which you have determined that your program and curriculum meet the state education requirement for licensure or certification. A list of negative licensure determinations. So a list of all the states for which you've determined your program would not satisfy requirements for licensure or certification. And finally, a list of no licensure determinations. So a list of all states for which you've just not made a call. In theory, every state ought to be accounted for, right? So you've got the states where you've made a decision, the states where you've looked, and you've got the states where you've made a positive determination, the states where you've made a negative determination, and all the rest of the states where you've made no determination at all. But all of this, for all those states, has to be available, which means you're going to have to track the states for which you've made a decision or not, and the states for which you've not made a decision. And you got to make sure that wherever you're making this information available, it's out there and and readily accessible and current. You've also got direct disclosures that you're required to make to students and prospective students in these licensure programs. Any program you decide is a covered licensure program, on ground or online. Prior to enrollment, you have to directly notify a prospective student if you've made a determination that the program does not meet state licensure requirements in the state in which the prospective student is located. Okay? So if you've got that list and you've made a determination that your program does not meet the licensure requirements, you got to let a prospective student know. What else does that mean? It means you've got to have an infrastructure in place at your institution so that you can figure out where prospective students are located, and you can connect them with this list so that you can make this disclosure. And it's a direct disclosure, not a make available, right? Or if you've not made a determination for their state, you got to let them know that too, right? So almost regardless, you're going to be telling students, and presumably, frankly, if I'm a school and I've got a positive determination, I probably want to let prospective students know that, right? So really what we're talking about from a practical matter is schools putting into place a mechanism by which they can evaluate for every covered licensure program when you have a prospective student, where that student is located, and you can connect with them and make the disclosures you need to make regarding whether for that jurisdiction you got a positive, a negative, or a no call with regard to the programs preparing them for the licensure. And remember, if you decide to early implement, that means you got to be ready to do that the day you early implement, right? Direct disclosures. Within 14 calendar days, an institution has to directly notify a current student if the school's made a determination that the program does not meet a state licensure requirement in the state in which the prospective student is located, okay? So if you had no determination, right, let's say you had a no call and you let the prospective student know it was a no call, and then over that same period of time before the student started, you figured out that you would not satisfy the state licensure requirements, now you got an obligation to update them, right, within 14 days of making that decision. So folks in the academic verticals are going to have to be coordinating in admissions verticals to make sure that these disclosures get made. Also, direct disclosure has to be made to the student in writing, which may include through email or other electronic communication. That's just a description of what that means to make a direct disclosure. The department also has included in the new reg some specific guidance around what it means to determine the student's location. So the school has to make a determination regarding the state in which a student is located at the time of the student's initial enrollment, and if applicable, upon formal notification that the student's location has changed to another state. So if the student lets you know, I'm changing, you've got to make a call now in your systems as to where you understand that student to be located, and you need to provide them any updated information. Determinations regarding a student's location must be made in accordance with written policies. Upon request, schools must be able to provide the department with written documentation of determinations regarding students' locations. So there's a lot to implement here. So let that soak in, right? I would talk with folks at your institution. Are we making the 2016 notifications? Do we understand what's required as of July 1, 2019? Are we prepared to implement, and do we want to implement early? But there's no scenario where doing nothing makes sense, right? I mean, you need to be complying with the 2016 rule already, and you need to be thinking about how to come into compliance with 2019. And if you offer a licensure program, this is going to impact you. And there are a lot of schools on the line, I have no doubt, that offer nursing programs, master's education programs, all kinds of programs that lead to forms of professional licensure. All right, bar defense. So, scope of the rulemaking. Most folks know we have covered this thing every which way from Sunday, and I was involved with it directly. So there's been a lot of presenting. You've probably seen this slide before if you like to listen into our webinars. You know, the rulemaking was broad and, like these others, complicated. The big showpiece was the claims framework, like how do borrowers make a claim? What are the standards upon which a claim would be adjudicated and a loan discharged? But also there was a lot of important stuff around the financial responsibility framework and the creation of these new triggers and reporting requirements. There were changes to the closed school discharge laws and false certification discharge laws. And then there was this conversation around the use of pre-dispute arbitration agreements and class action waivers. So a lot of ground covered. The department really started back in 1994 when we had our first, what I'll call BDR1 rule that came out. and that was in place for 20 years. It was a pretty simplistic concept, actually. And then in 2016, the prior administration decided we needed a new bar defense rule, and they were probably right. I mean, we went from having a couple hundred, maybe I've heard different numbers from single digits to 100 plus, but a very small number of bar defense claims filed over 20 years to suddenly having tens of thousands filed in the wake of the Corinthian closure and the ITT closure in particular, but also with relation to other schools as well. And the upshot of that is the department needed a legal framework that would provide for the adjudication of those claims in addition to an operational framework in-house. So they went through a complicated rulemaking and came up with a version that they put out 2016. This is going to start looking a lot like our state authorization conversation. This administration acted to delay that rule. That delay ultimately was found to violate the Administrative Procedures Act, with the result that in the fall of 2018, the 2016 Bar Defense Rule, what I'm calling BDR2, suddenly became effective, and it is the law of the land. The department simultaneously was negotiating a new bar defense rule, which we saw in final form earlier this year, which allowed it to go into or become effective next year, July 1, 2020, right? So a number of things to keep in mind here. The complying with the 2016 rule was really complicated because there was this significant period of time that passed between its what was supposed to be its effective date of July 1, 2017, and when it sort of actually became the law of the land back in October of 2018. And so it was earlier this year in March when this administration said, okay, we understand the 2016 rule is now on the books and schools need to know how they can comply with it, in particular for events and things that may have occurred from July 1, 2017 to present. So we're going to issue some guidance, and they did ultimately in March of this year, talking about coming into compliance with the 2016 rule, which remains the law of the land until July 1 of next year, okay? I want to focus on a couple of things. The first is I'm just going to remind you, if you listened to our webinar we did this summer, we talked about the changes in financial reporting, and in fact, I mentioned earlier, we've covered this thing every which way from Sunday, so I'm not going to go through all of this again. What I want folks to understand is, again, the 2016 rule, BDR2 as we call it, is in effect right now. And there are reporting requirements under that rule that you're supposed to be complying with. And there are new financial responsibility triggers that if they occur, you're supposed to be giving the department a heads up. And that's not going to change between now and July 1 of 2020 next year. There's no early implementation concept that applies to these obligations under the law. Now, come July 1, 2020, there will be a new law of the land, and there will be updated triggers and reporting requirements, but those won't go away. They're just changing. So this administration didn't get rid of these concepts like the triggering events and reporting requirements. They just changed them. So you've got a set of reporting obligations that are in place until July 1 of next year, and then after that, you're going to have a new set of reporting obligations. But either way, you need to be current on what has to be reported to the department, and you need to be making some effort to comply, of course, with the law that's in place now and will be in place after July 1 of next year. So, look, we did a comprehensive webinar on the reporting obligations under BDR2 earlier this year. It is available on demand and free. You can click over to it. And I mentioned at the outset that there are a couple of things that we included in the resources widget. So they're reporting guides. I've got two of them for you. The first is the reporting obligations under the current law, BDR2, or the 2016 Bar Defense Rule, right? And the second reporting guide that's in there, and make sure one says 2016, one says 2019, make sure you see the difference. The second one are the reporting obligations that will be in effect as of July 1 of next year. So you've got two different documents. You can refer to each of those, right, to understand what your obligations are under current law and under the law as of July 1 of next year, at least your obligations around these reporting requirements. We also did two webinars in September of this year, right after the new 2019 rule came out. I think we did them, maybe it was October, Two 90-minute webinars where we walk through in great detail all aspects of the 2019 BDR3 or Bar Defense Rule. So I'm not repeating that here, but if you need a refresher or you want to go through that, again, click the link. They're both there. They're free and on demand. So we got a lot of good content for you here to help you get into compliance. What I want to talk about right now is what's going on with the department and their efforts to implement this bar defense, the current 2016 framework and the framework that's coming at us. So if you didn't see it, on November 25th, right before Thanksgiving, the department posted a couple of electronic announcements. In the first, they said they will soon begin to send notices required under the 2016 final regulations. So they said, what we're going to do is we're going to start sending the school associated with the borrower's allegations a letter and a copy of the borrower's application and invite the school to respond and provide information relevant to the borrower's allegations within 30 days. Okay, so the department right now is sitting on close to 200,000 borrower defense claims. It is not my expectation that they are going to issue 200,000 letters all at once to institutions, right? I don't think that's going to happen. There are a host of bar defense claims, mostly by Corinthian students, that are tied up in litigation right now out in California, and I don't think there's anything the department can do about those. But there are a lot of additional claims, thousands, that are not tied up in that litigation. Some of them involve Corinthian students, some of them involve ITT students, both closed institutions, and then there are a bunch of others. Now, I know there are a lot of traditional schools on the line. I've got public institutions, private nonprofits, and we did a blog a couple of weeks ago on this topic, and I just want to reiterate a point here. It is absolutely true, that the vast majority of these bar defense claims that are out there, the 200,000, relate to a small number of schools. Probably 5 to 10 is what we've seen from the information that either has been made publicly available by the department. There was some data that was given to us when we were negotiating the 2019 rule. There have been some FOIA requests by news outlets, right? And everything suggests that the vast majority of these claims relate to 5 to 10 schools, and that most of those are for-profit institutions, right? And most of them, frankly, are Corinthian and ITT. But there's still that 10%. And when you got 200,000 claims outstanding, that's 20,000 claims, right? And that's a lot of loan money that's tied up with just 20,000 claims. The department to date has discharged a little north of 40,000 claims, and that's over $500 million that they've discharged tied to those 40,000 plus claims, right? So, you know, how much those discharges are for can vary, but what I want schools to understand is in the current climate, where, you know, the Democratic candidates, when they're debating right now on national TV, are talking about, you know, the cost of college education and loan debt and free education. I mean, these ideas around college and university education being expensive and there being a lot of debt burden being put on to students, I don't think they're going away, and they're top of the news cycle. And they're very much on the mind of your students. You know that, right? And this borrower defense discharge framework, this opportunity to seek discharge of your loans, is available to all of those students, not just students in any particular sector, or borrowers, I should say. So it is hard for me to believe that over time, with the department and various consumer protection outlets and others making information about bar defense discharge available, with journalists and presidential candidates talking about the cost of college and debt relief, it's just hard for me to imagine that over time borrowers aren't going to start to clue in. So I think it's very important, whether you are at a for-profit institution or a nonprofit or a public institution, that you be aware that this claims process is out there and that these letters are going to start going out, and that this administration, certainly the subsequent administrations, are going to start figuring out how to process these claims more efficiently and get letters out, right, to institutions. And I think that you're going to see institutions in all sectors of higher education that get these letters, and it doesn't take many to have at least something to be interested or concerned about, right? I mean, if you've got 5 bachelor's degree students who each have $80,000 of debt and they all file claims, right? I mean, you got hundreds of thousands of dollars suddenly in loan discharge that you're dealing with. So it doesn't take 20,000 or 10,000 or even 1,000. I mean, it could take 5 to 10 to get to a number that would potentially get your attention. So all of the wheels are just now starting to turn. I don't think folks are going to start getting hundreds of letters anytime soon. That's not what I'm suggesting, but I am suggesting that the wheels are starting to turn, and you want to be aware of that. Now, I've not seen anything publicly available where the department talked about the process and sort of its approach to getting through these claims, but Politico and then a couple other news outlets claim to have gotten an internal memo from the department, and I don't have any reason to think that claim is not true. They didn't make the whole memo available, but they quoted from it. And they suggested, and this was an internal agency memo written by a senior staffer at the department about how they were going to approach these claims. Politico reported that the department, according to this memo, wants to begin with these 30,000 or so Corinthian claims that are outside of the class action lawsuit, right? And then move on to approximately 28,000 claims filed by ITT Tech students and students at some other colleges. And the internal memo noted that adjudicating these claims will probably take a very long time. And it's incredibly difficult because all of these claims, and in fact, every claim that's been made to date, will be adjudicated using the 2016 process. And in fact, any claim made between now and July 1, 2020, and even after that, if the underlying loan was dispersed before July 1, 2020, so forever and a day, at least under current law and even under the 2019 rule, right, if the underlying loan is dispersed before July 1, 2020, the process that will be applied is the 2016 Obama-era borrower defense discharge process, right? The standard will differ depending on whether or not those underlying loans were made before July 1, 2017 or after. If it's before July 1, 2017, which is all the stuff they're talking about here at Corinthian and ITT, or most of it, then the standard is whether or not the claim gave rise to an action under state law, which means you've got a bunch of staffers at the department who've got claims from folks who were in school years ago, and these staffers have to figure out whether or not the claim or the allegation would give rise to a violation of state law, presumably in the state where the student was resident, although that's not even clear. What if it's an online program? Is it where the school is located? It's a quagmire. It's a quagmire, and that's why it's going to take a long time to get through. But again, the wheels are turning. The other thing that you may see much sooner, and this is something, too, that I think a lot of schools may not be keyed into. So the department also on November 25th notified institutions that it's going to begin the process of collecting on the automatic closed school loan discharges that it began processing in late 2018. So under BDR2, the 2016 rule that the prior administration put into effect, there's an automatic closed school loan discharge, which says that any schools that closed after a particular date in 2013, right, the department's going to sweep their systems. And if you had students who withdrew from that closed location within 120 days of the last day you offered instruction, if they withdrew, right, or if they were still enrolled on the day you closed, and then they did not subsequently enroll in another school, right, they may be eligible for a closed school loan discharge. And here's the important thing to keep in mind is I can't emphasize this enough. There aren't a bunch of human beings at the department doing this analysis, right? They've put together an algorithm, and they have a system that is just sweeping information in the department's databases and in NSLDS, and it's sort of saying, look, if we've got someone who it shows that they withdrew and they were a closed school and the school closed after date X and they didn't enroll and we don't have any data that shows they enrolled in another institution or transferred their credits after that, then it's an automatic discharge. And it generates a letter. Actually, the first thing that happens is they discharge the loans. Let me be clear about this, too. In the case of closed school loan discharges, to date, unless the department changes the way they've always done it, they discharge first and then ask questions later. It's not like bar defense where they reach out to the school in advance. They don't do that. So they're going to grant automatic discharges, discharge the loans, and then they'll reach out to the schools and say, we automatically discharge these loans because you had a location that or a school that closed so many years ago, but within the window, right? And this is the amount you owe us. And that's it. That's how it's going to work. So you've got a massive sort of process that's happening at the department. Now, a lot of you on the line may say, well, you know, our school didn't close, so this doesn't apply to us. Here's the kicker. The closed school loan discharge provisions don't just apply to schools that close. They apply to locations when they close as well. So if you are at an institution that has locations around the country or internationally, you had that location in Bangkok that didn't work out 6 years ago, so you guys decided to wind it down. it could be caught up in this, right? Because if it was sitting on your e-card, that's your eligibility certification approval report, that's the document that the department has in their systems that shows what locations you have that are approved for Title IV, right? If you had an approved location with the department between 2013 and the present, and that location at some point closed, it's going to get caught up in these processes. And if you had students who withdrew within 120 days, then it's possible they could show up as eligible for a closed school loan discharge. And here's the thing. The department doesn't have a way in its systems, for example, to identify the basis for which somebody was withdrawn. I have had situations, and I'm working with a school right now in a situation, where they had a student within 120 days of the day they had a location closed that was actually withdrawn from the institution because the student failed. They actually failed out, right? But it showed up as a withdrawal in the department systems. And the school reached out to the department after the fact and is actually right now having to argue with the department over whether or not that student should be eligible for a closed school loan discharge. Of course, they said the student didn't drop out because the school was closing. The student was kicked out because they failed out. And the department said, well, it's hard to know. And this was 7 years ago, and we need to see some records showing it. Tricky business. So I'm here to tell you, whether you are a for-profit or a public institution or a private nonprofit, if you've got locations that have closed since 2013, you need to be thinking about this because you may get one of these letters. And my advice to all of you with regard to bar defense and closed school loan discharge is to keep in mind that it's complicated, that a lot of this stuff is automated, that the standards are complicated, it's new to the department and the people trying to administer it. So if you get these letters, there's probably going to be opportunity to look very hard and see if errors were made. So just be deliberate about that opportunity and take advantage of it. What else is going on with bar defense? Boy, it's just the Wild West out there. You know, in May 2018, I mentioned earlier, there was a federal judge that blocked the department's attempt to provide partial relief to a group of former students, mainly Corinthian students. Interestingly enough, the ruling was based on the fact that in order to do what the department wanted to do, they were violating privacy issues around the use of earnings data from Social Security Administration, or there were privacy issues. It really wasn't about whether the method for granting partial relief was acceptable or unacceptable. It was just the mechanic couldn't work within the confines of the law. On December 10th, just a week and a half ago, in an effort to move forward, the department announced a new methodology for determining how they're going to grant partial relief if they want to grant partial relief. I want to emphasize, sometimes it's hard to discern from the press, but the department and the issue here is not whether or not to discharge or which process applies, whether it's the 2016 or the 2019, all that's very clear. What the department is trying to decide is how much to discharge, because they have retained the position under the law, they don't have to grant full relief. And this administration said, we think, and even the prior administration, if you go back and look at the 2016 regulation and the commentary, I mean, they were throwing around a lot of different ideas about, if we think there's been some wrongdoing on the part of a school, how do you determine whether or not to discharge the whole loan or a part of it? I mean, the last administration also retained the right and believed it had the right to ostensibly grant a partial relief, and they, again, floated several different ideas for ways to do that. This administration said, we think it ought to be a measure of financial harm. In other words, how much financial harm did the student incur, the borrower, and then that's how much relief they ought to get to cover that financial harm. So all of this is about not, the underlying claim process or the standard. It's about how to determine how much discharge or relief to actually grant to the student. That's where the big debate is. So the department announced a new methodology, and then everybody hated it or loved it along political lines. On December 12th last week, Secretary DeVos was up at a hearing and got absolutely hammered by the Democrats. So it's hotly contested right now. And meanwhile, it's worth noting that the Democrats in their College Affordability Act, which is their effort to reauthorize the Higher Education Act, at least sort of the current version of it, they would codify a lot of the stuff from the 2016 Bar Defense Rule and would make changes in statute that would require changes to the new 2019 rule that this administration has just put out. So, a lot of stuff still up in the air. Looking ahead, again, put into place a protocol for the receipt and management of BDR or closed school discharge letters if you get them. I just want to make sure if they come in, somebody sees them, somebody's aware of what they are, and that the right parties at your institution are taking a hard look, because I think there's going to be a lot of room for error in the way that the department, and that's not a shot at the department, it's just big and it's complicated and unwieldy, and these are difficult regulations to implement. So they're using automated systems, they're doing things for the first time. They got staffers who aren't lawyers trying to interpret, claims processes and standards, and, there's going to be room to push back. In some cases, you might have frivolous claims, and there might be every reason to push back. So just be aware that the wheels are turning. Okay. The last two are going to go quick. So the big news on Title IX, I'm not going to go through all these slides in great detail. I've got the scope of the rulemaking up here. I've got a timeline for you. We talked about this summer. Last year in November, the department published its proposed Title IX rule. It would be the first rule or regulation from the U.S. Department of Education governing the management of sexual misconduct on campus in 40 years. Everything we saw to the prior administration was in the way of guidance. It wasn't actually regulation, so this would be the first one. This has been hotly contested. The department received over 100,000 comments. The Democrats in Congress hate this rule. A lot of consumer advocates hate it. A lot of schools find a lot of parts of it problematic, but the administration has vowed to move forward and get it out the door. They say by this December. Any day now. I'm still hearing that out of various bureaucrats on the Hill, and other sources that I talked to are reporting that that's what they're hearing as well, although it also has been noted that OMB has scheduled meetings on this rule into February, which doesn't necessarily suggest that December is going to be the day or the month, rather, that we see the new rule. But it supposedly is imminent. If it's not December, January, February, but this administration seems very set on getting it out the door. So keep an eye out for it. It's going to be a big deal when it hits. There's going to be lots of coverage and commentary. We will almost certainly do a soup to nuts deep dive on the new rule when it comes out. And then finally, and by the way, we did do a soup to nuts on the proposed rule last year. And if you have an interest, you're welcome to go back and listen to that, and it really goes through all the different parts of the department's proposed rule. And finally, gainful employment. Nothing has changed since this past summer, but I included the slides here again, in part just to be complete, because that has been part of the department's agenda for this year, and this is a year-end wrap-up. The department, this administration, earlier this year essentially rescinded the prior administration's gainful employment rule. You had the opportunity to early implement that rescission. Otherwise, you have to continue complying with gainful employment through July 1 of next year. So just keep in mind, if you do not want to keep complying with the gainful employment rule, you do have to early implement. It's not hard to do. You can look at the department's electronic announcement. They give you instructions, and we actually even did a blog that included as an attachment a model rescission form if you're interested, and it's out there still on our website. Finally, we do lots and lots of webinars. We try to provide lots of good content, hopefully, like this webinar, to the regulated community, to institutions of higher education. We hope you find them useful, and they are out there and they're free. So please, if you need some assistance or you're looking for a review, check it out. Our blog, similarly, we are writing all the time. We just posted a blog yesterday about the CCPA, California's cybersecurity data privacy law. So feel free to go over and check that out. And keep a lookout for our guides and things like that as well. All of that having been said, how about some questions and answers? We'll see what we can do here. I did get a question. Actually, somebody posted a question before the webinar even began, and it's not related directly to the stuff we covered here, but I will take a look at it and try to get back to you. But I'm going to skip it here. Let's see. Do the consumer info boot camp. Duly noted. All right. We would like to do that. I think that would be a really good thing to put together for institutions. Let's see, is it correct that covered licensure program doesn't just mean a true licensure, like, say, nursing, but also national professional certifications, like KHEP for surgical techs is the example they give here? Well, I think what they are saying is if it's a type of licensure that someone has to have in order to practice in the profession that the program says it is preparing that person for, then it's required. Right? That's the tack that the department takes in the regulation. Or if you are advertising that you prepare folks to get this certification. So in that case, even if it's not required, say, under some state law for someone to practice, but if it is an industry-recognized credential and you advertise that when you finish our program, you can go get that credential or certification, then your program better prepare them to do that, right? Let's see. If we are a community college, not approved to have students from other states attend our college, so all students are residents of our state, do we still need the licensure disclosures for other states? If you have a covered licensure program and you're a Title IV program, I think you do still need to make the disclosure, but I think you could very easily just say, we have only made a determination with regard to our own state. And we've made no determination for any of these other states, and you should never have an issue. So that's just a single disclosure, right? No determination, because you have to have those three lists. So you've got the one for your state, you don't have anything on the no list, and on the no-call list is every other state. You just say, look, we don't make a determination for any other state because we only enroll people from our state. It's an interesting, great question, yeah. Let's see. Because state authorization of distance education programs, final rule, reciprocity, only extends to distance education, does this mean a school may be required to obtain state authorization if enrolling students residing in another state for a 100% ground program, even if they are SARA approved? This is a great and interesting question. So the question is, let's say we are University X, and I'm just going to make this up. We're in Louisiana. I'm from Louisiana. Go Tigers. So let's say I'm an institution in Louisiana, and I have a location that I decide to put on the ground in the state of Georgia. But I also decide that my Louisiana home campus is going to offer online programming to residents of Georgia. So I'm in SARA, and I'm supposed to be able to offer that online programming, 100% online, to those residents of Georgia, because Georgia is also a SARA state, without going through any state authorization hoops. But I've got a physical on-ground campus in Georgia. So what happens? What does Georgia say? So what's interesting is a lot of states have been thinking about this. A couple of them I don't think have figured out an answer yet. From my information tells me North Carolina, for example, the jury's still out. There are some that have said, you know what, if you're authorized under SARA, even if you have an on-ground presence here, we're going to be okay with it because you're sort of authorized through this reciprocity. There are others who've said, no, the on-ground location still has to be approved. You got a physical presence. You got to approve the on-ground location, but the online stuff doesn't have to be approved. And yet, there are third states who have said, look, if you're in SARA, that online programming being beamed in is covered by SARA, so you don't have to deal with us. But if you create an online campus here, you have an on-ground presence, SARA's off. It doesn't matter. So now, not only does your on-ground stuff have to be approved and licensed by us, but the online stuff does as well, because your institution, both your home campus and your branch campus, now, from our perspective, have a physical presence in our state. So SARA no longer applies, and everything you do here, online or on ground, has to be licensed. So it's state by state. So if you've got that interesting situation where you are online and on the ground in a foreign jurisdiction, you have to talk to that state and figure out how they're going to treat that. And it is absolutely possible, and there are states who have said, in that circumstance, we no longer recognize the state reciprocity that would otherwise cover your online programs because your school has a physical presence in our state now. It's really an interesting riddle, and it's one, again, that is going to require some examination. Let's see. Somebody just talking about maybe talking about competency-based education, noting that the Department of Ed recently dropped the experiment on competency-based ed. And we actually, interestingly enough, my partner Chris Murray and I, a few years ago for the American Enterprise Institute, wrote a white paper on the regulation of competency-based education, and that was sort of in the context of that experiment that was ongoing at the department, experimental program. Yeah, we could definitely talk about that. So that's a couple of good topics, consumer information and competency-based ed. Let's see. And one more here. New York requires an on-the-ground location. This is a very specific question. I may have to pass on this. New York requires an on-the-ground location to be licensed. Can a New York resident attend a distance learning program and attend clinicals in New Jersey where the school is licensed? I'm going to pass on this because this is so specific. This gets into the realm of providing legal advice. But you know, it does highlight the extent to which these questions are so complicated, right, around distance education, and really can take a lot of very deliberate thinking, particularly where you've got clinicals involved and things like that. Hey, that puts us right at 1:30, and that's all the questions. Thank you guys so much. I hope you have a wonderful holiday season. I hope people stay safe on the roads and in the weather and healthy. I know it is also the time for colds and flus and things of that nature. Keep us in mind. Watch for more emails about blog releases and webinars, and we will see you in the new year. Happy holidays all.